Sorry. I took a nap yesterday after I said I wasn't going to take a nap, so I get some sleep.
military and autocratic, as my teachers my students will tell you. Welcome to the annual Law Day program, and to LSUS if you haven't been to LSUS before. My name is Bill Peterson. I'm head of the International Lincoln Center, and this is the third year that the Shreveport Bar Association has sponsored this program. They've moved it up a day or two just for us. Because Law Day is not until June 1st, correct? May 1st. Excuse me, May 1st. And they've done this just for us. The first year they did it, we had 50 people. Last year we had 75. And when all the seats are filled, we'll have 125 in here. And then beyond that, it'll be United Airlines Part 2. Okay. So I would like to introduce our co-chair of the Law Day program with the Shreveport Bar Association, Mr. Drew Burnham, who's going to be one of the speakers too. He graduated from college, Centenary College in 2012. Then he went to LSU Law School, was on the law review there, and graduated in 2015. And then he became a law clerk to Judge Elizabeth Foote, and now practices law at the law firm of Cook, Yancey, King, and Galloway. With that, because we're short of time, Drew Burnham.
Thank you very much. Thank you all for being here so early in the morning. He must have given a lot of extra credit. But I hope this presentation is informative for you all, and because the point of Law Day, the reason why we celebrate it every single year all across the nation, is to try to educate the public just a little bit about a particular area of law, but overall encourage just the appreciation for the role that law plays in our society, keeping order, giving rights, and making, just really kind of giving the tone for American citizenship that we all enjoy here. So we have 4 speakers today. We have me, Drew Burnham. I'm going to be talking about the citizenship clause of the 14th Amendment. Mr. Flanagan, William Flanagan, was a U.S. attorney and is now retired. But he's going to discuss the beginning of the 14th Amendment, like the drafting, what happened with the situation before the 14th Amendment, what was the purpose of the 14th Amendment. After I talk about the Citizenship Clause, Brian Flanagan is going to talk about the Equal Protection Clause of the 14th Amendment. And Timothy Wynn is going to talk about the Privileges and Immunities Clause and Due Process Clauses of the 14th Amendment. So, questions are welcome. We might, through our presentations, ask you questions, so please feel free to participate by answering those questions, raising your hand if you think you might have an answer for that. Also, if you have any questions, during my presentation, feel free to raise your hand at any time and I'll try to answer any questions that you might have. If they might offer that situation to you, but at the end of their presentations, we'll have time for some questions. Hopefully, we'll have some time for that. So without further ado, Mr. Flanagan.
Well, good morning to all of you. Thank you for being here so bright and early on a Friday morning. Thank you to Dr. Peterson for inviting us back to start Law Week here at LSUS. This is the 3rd year we've done this. The first year we spoke about the Magna Carta. It was the 800th anniversary of the signing of the Magna Carta. And last year we spoke about the Supreme Court case of Miranda versus Arizona, which everybody knows about. It was the 60th anniversary of the Supreme Court's decision of Miranda versus Arizona. This year we have a challenging assignment. We're going to talk about the 14th Amendment. The 14th Amendment was passed by Congress in 1866, was ratified 2 years later. And it's a challenging assignment because there is so much in the 14th Amendment. Some constitutional scholars refer to it as America's second constitution, things like that. And it has so much impact and influence on our daily lives today. Things like due process and equal protection and privileges and immunities and the Citizenship Clause and what does all that stuff even mean and why did we even need a second American Constitution. So what we thought we would do, try to talk about this in some coherent and hopefully interesting way, is to start by spending a few minutes on where did this come from? Why did we get the 14th Amendment following the Civil War? And what were some of the, put it in some sort of political and historical context for you before we spend most of the hour talking about the substantive portions of it. So to understand the 14th Amendment, America's second Constitution, you have to go back a little bit to talk about America's first Constitution. The original Constitution was drafted in Philadelphia in 1787. And the story is pretty well known that the debate was between the large states and the small states, and what was this new Congress, this new national legislature going to look like. And the large states thought it should be based on population, and the smaller states thought it should be based on every state being equal. So a little state like Delaware said, why don't we have a Congress in which each state has one vote, which is how it was with the Articles of Confederation. The largest states like Virginia said, you must be joking. You think a state like Virginia, with our population, with our economic power, we should have no more say in the national legislature than Rhode Island? Doesn't make any sense. And the great compromise was, okay, we'll have two houses in the legislature. In the National Congress, we'll have a Senate in which each state has an equal vote, and we'll have a House of Representatives in which the members are apportioned, just the fancy word, according to population. Everybody knows that story. But how are we going to apportion the people? So the 1787 Constitution says in Article 2, the House of Representatives shall be composed of members chosen every second year by the people of the states. How do we count those people? And the debate here became not between large states and small states. It was between states that had a slave population and states that did not. The southern states with a slave population said we should count all the people, including the slave population. And the northern states said, wait a minute, you have a slave population that has no civil rights, has no political rights, they cannot vote, and you want them to be counted, though, in terms of apportioning members in the House of Representatives. And the southern states said, well, they deserve to be represented even though it's a slave population. But the debate really here, as it so often is, was about power, was about political power. Because if the southern states could count the slave population, which could not vote, but nevertheless be counted in terms of apportionment, then they would have a greater number of members of the House of Representatives than the northern states. And since it's the number in the House of Representatives that determines how many votes a state gets in the Electoral College, they would also have a greater advantage in choosing who is the President of the United States. So it was resolved back in 1787, as many things were back then, with a compromise. And the compromise in the Constitution back then said that the representatives shall be apportioned according to their respective numbers, determined by adding the whole number of free persons to the whole number of free persons, 3/5 of all other persons. That all other persons, that was the slave population. So it was, they would be counted, but only counted as 3/5. James Madison, back in Philadelphia, kept a journal during the Constitutional Convention, and he wrote in his journal that the great divisions in the United States are not between large states and small states. The great divisions are between the North and the South. He wrote that in 1787. So fast forward now to 1865. The Civil War is over. Lincoln is dead. Slavery is dead. 13th Amendment passed in 1865 and outlawed slavery. And now the question is, how do we put the country back together? How do the southern states now be readmitted to the Union? And had in fact they ever left the Union? Because the northern states, the argument was, you have no right, a state has no right to leave the Union once it enters it. There's nothing in the Constitution that speaks to that. So the southern states now defeated in 1865 said, okay, we never left the Union. You're right, we lost. We will just lay down our arms and rejoin the Union. And the Republicans in Congress, the northern Republicans, the radical Republicans, they were having none of that. They said their view was the southern states committed political suicide, and they are a defeated nation. And the only law that applies in the South is martial law. But once again, the debate was over political power. Because if the southern states were just readmitted to lay down their arms and be readmitted to the Union, then when the House of Representatives was being apportioned, now the slave population is no longer counted as 3/5. It's counted as a whole population. And in fact, the people who ran the numbers said once they do the census in 1870, when the House of Representatives is apportioned again, if you count all the slave population, the now former slave population, not as 3/5, but as a whole, it would probably give the southern states an extra roughly 30 members of Congress, and an extra 30 electoral votes in the Electoral College, which means the president is probably going to be Robert E. Lee. And the southern states, along with the northern Democrats, will dominate the Congress. And having lost the military battle in the Civil War, the southern states will have won the political battle in terms of influence, in terms of political power. So, what to do? So the Republicans in Congress, at the time, they had a number of constitutional amendments that they were over 160 possible constitutional amendments were offered, but the one that became the 14th Amendment, it turned into a debate of, will we let the former slave population, will we let black people vote? And we could pass a constitutional amendment which said that black people were now entitled to vote. And if black people in the South could vote, even though they're fully accounted for in apportionment, at least there'll be a true two-party system. But there wasn't enough support for that in the Congress, because any constitutional amendment has to be approved first by 2/3 of each house of Congress. And the fact was, back in 1865, in a lot of northern states, black people couldn't vote. They couldn't vote in Wisconsin, they couldn't vote in Minnesota, they could not vote in Connecticut, they could only vote in New York where they owned property. There wasn't a lot of support back in 1865 in the Congress, even in the North, to allow black people to vote. And what about women? Women could not vote, but they were counted for purposes of apportionment. So that if there wasn't going to be a constitutional amendment to allow black people to vote, they thought maybe we could persuade southern states to allow black people to vote. And this is what they passed in the 14th Amendment. This is 14th Amendment, Section 2. Representatives shall be apportioned among the states according to their respective numbers, counting the whole numbers of persons in each state. Fair enough. None of this 3/5 business. But if a state denies the right to vote to any male citizen, 21 years or older, then the basis of representation shall be reduced in the proportion to which the number of male citizens bear to the state. Which is to say that if a state allows black people to vote, then they will all be counted for terms of apportionment. If they will not be allowed to vote, then they will not be counted at all, not even 3/5. And the idea was in the 14th Amendment here in Section 2 that would persuade the southern states to allow black people to vote. If they were not going to guarantee, though, the right to vote in the 14th Amendment, then the members of Congress thought we have to do something to guarantee the former slave population some civil rights. Otherwise, we leave them to the mercy of the white population that dominated governments in the South. And so they passed they included the first section of the 14th Amendment. And we said we will put in here rights that each citizen will have and are guaranteed against any interference from state governments. So in the first clause, they put any citizen born or naturalized in the U.S. is a citizen of the U.S. and the state where they reside, and no state shall make or enforce any law to abridge privileges and immunities, to deprive a person of life, liberty, and property without due process, to deny equal protection of the laws. And it is this clause that became the engine which generated so much of the development of the Constitution going forward that we'll talk about for the rest of the hour. So what you had here in the first American Constitution, you had a Bill of Rights, which was designed to protect citizens from what people feared would be an overbearing national federal government. By 1866, now is the second Constitution, which protects citizens from state governments. And that protection will be afforded to them and will be protected by the national federal government. So that's just a little bit of the context how we got the 14th Amendment. It was written and passed by Congress in 1866, was ratified 2 years later in 1868. Each southern state ratified the 14th Amendment as part of being readmitted to the Union to have their congressional delegation seated in the House and in the Senate. And then this first clause has been developed by the Supreme Court since then and going forward all the way to today. So with that, we'll start with the citizenship clause.
Okay. Thank you, Mr. Flanagan. So, Mr. Flanagan has already read this citizenship clause, which is the very first clause of the first section of the 14th Amendment. But I want to highlight three words. First, born. Second, naturalized. And then third, this last little clause, this middle clause here, in subject to the jurisdiction thereof. So, and all it reads is, it reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and other states in which they reside. So, I assume we all know what kind of get an understanding of what born in the United States might mean, but what does naturalized mean? Does anybody know what naturalization is? Yes, ma'am.
When you're not born in the United States
And you become a citizen. The Congress lays out some kind of mechanism by which you can become a citizen of the United States if you were not born a citizen of the United States. That's from Article 1, Section 8, Clause 3, gives Congress the power to write a rule, to pass a law delegating how to some department of the U.S. government, how people can become citizens of the United States. So we have born in the United States and we have naturalized in the United States. But the key phrase also becomes, as this clause is developed by the Supreme Court, and subject to the jurisdiction thereof. That phrase is not defined anywhere inside the 14th Amendment. But does anybody have an idea what that might mean? Yes, ma'am.
I would assume that if you're not a natural born or naturalized citizen, but you reside illegally within borders.
So subject to the jurisdiction thereof might become an issue, yeah, if you might not be living inside the laws of the country that you're living in. That's a good point. That's a good idea. Does anybody else have an idea of what that might mean? Yes, ma'am.
What if you're on a military base in Japan or something?
That's a really good point. There are on most bases that the United States have, we interpret that as sovereign territory, where if you're born on it, you're interpreted to have been born for purposes of the Constitution as a U.S. citizen. But that is that's subject to debate, especially, we might have time at the very end when it comes to presidential qualifications. I'm sure a lot of y'all have heard about that debate over where some people are qualified to be president of the United States. Ted Cruz comes to mind, Marco Rubio comes to mind. Back in the day, Mitt Romney's father, George Romney, when he ran for president, he was born in Mexico, so there was a debate whether he was qualified to become president. So that's a different clause of the Constitution, but we might be able to catch that at the very end. So those are the key words moving forward. So let's explore what subject to the jurisdiction thereof means. So the first case we run into is just a few short years after the 14th Amendment is passed, and involves an American Indian who was born on a reservation in the United States. He was a Winnebago Indian, and he decided that he didn't want to be an Indian, have his citizenship be Indian anymore. So he moved off the reservation, renounced his Indian citizenship, renounced his tribal citizenship, and tried to register to vote in Omaha. However, he was refused the right to vote in Omaha, Nebraska, on the pretext that he was not an American citizen. The registrar of voters there concluded that he was born on Indian territory and was not subject, that clause, subject to the jurisdiction of the United States because he was American Indian. So this went all the way up to the Supreme Court, and the Supreme Court concluded, well, first, I guess it's worthy to note, to describe the situation American Indians were living in at that point in time. So I'm just going to quote from the Supreme Court here. What the question faced by the Supreme Court was whether an Indian, born a member of one of the Indian tribes within the United States, is merely by reason of his birth within the United States, an American citizen. So the state of the Indian tribes in the nation at that point was the Indian tribes, being within the territorial limits of the United States, were not, strictly speaking, foreign states, but they were, quote, alien nations, distinct political communities with whom the United States might sometimes deal, through treaties passed by the Senate and the President, or might be interacted with through acts of Congress. But, this is the key phrase, the members of those tribes owe immediate allegiance to their tribe and were not part of the people of the United States. So, the unique situation of the American Indian at that point in time was that they were inside the territorial jurisdiction of the United States. They were within the borders of the United States, but they were not interpreted to be subject to the jurisdiction thereof because their first allegiance was to the Indian nation in which they were born into. So, that was the first major interpretation of that clause, subject to the jurisdiction thereof, and really the first major case dealing with the interpretation of this first clause of the 14th Amendment. So, and ultimately the Supreme Court concluded that he was not deprived of his right to vote because he was not a U.S. citizen. The next case is a little bit more advanced, right at the turn of the 20th century. And it involved a Chinese-American cook named Wong Kim Ark. Now, it's very important to realize the terrible situation that Chinese immigrants were subjected to as they came to the United States at this point in time. Chinese immigrants were met with considerable distrust, resentment, and discrimination, most of them coming in to California. A lot of them, they were pivotal in building the Transcontinental Railroad. Many of you all might have been exposed to that in history class. But they were a significant minority population in many communities out in California. Many politicians argued, now it's pretty strong language, that the Chinese immigrants were so different in many ways that they could not assimilate into American culture. And that not only some politicians argued they could not assimilate, but they argued that they were a threat to the country's principles and institutions. Now, in this very popular anti-Chinese immigrant culture, the Congress of the United States of America, this is not just California passing this law, but it's the United States Congress passed a law called the Chinese Exclusion Act, which limited Chinese immigration to the United States. Already in the United States, Chinese immigrants could not become naturalized United States citizens. At that point in time, the law stated that the only people that were eligible for naturalization were white, free citizens. So, when Wong Kim Ark's parents came to the United States, they were not eligible to be U.S. citizens. So they were Chinese immigrants, Chinese citizens, and Wong Kim Ark was born in San Francisco. So, knowing that clause, talking about born in the United States, it seems pretty straightforward, right, that he would be a citizen of the United States, just looking at the language. But when we turn again to that subject to the jurisdiction thereof clause, it gets a little bit more hazy. Wong Kim Ark went to China to go visit his parents' homeland. And what was that year? He visited in 1890. He returned in July of 1890, and he was readmitted to the United States without any problem. But he left again in 1894, sailed to China for another temporary visit, then came back in August 1895, and he was detained in the port of San Francisco. The collector of customs there said he was not a U.S. citizen because while being born in the United States, he was not subject to the jurisdiction thereof. Sounds familiar to our earlier case with John L. So, the relevant facts are he was born to Chinese citizens. He was a Chinese citizen himself because Chinese citizenship was granted based on birth. And he was born on United States soil. So what do y'all think? Is he subject to the jurisdiction of the United States, being born there, being born on American soil? Anybody have any thoughts on that? I think so.
I'll say you.
I think that's a pretty good argument for it. Let me read y'all one of the opinions of the justices and see if this might sound reasonable to y'all. The two justices argue that it is not open to reasonable doubt that the words subject to the jurisdiction thereof that we find in the 14th Amendment was supposed to be synonymous with words that we find in an earlier act of Congress called the Civil Rights Act of 1866, the words there being not subject to any foreign power. So there, some Supreme Court justices thought that subject to the jurisdiction thereof in the 14th Amendment meant not subject to a foreign power. So they argued, in their opinion, that subject to a foreign power meant that if you had your first citizenship, if you had your primary, they try to identify a primary citizenship, then you were not subject to the jurisdiction of the United States because your first loyalty was to the nation of your parents. So this was not ultimately the conclusion that the Supreme Court arrived at, however. The Supreme Court kind of tried to strip away all of the kind of purpose-based arguments that the dissent put forward and stripped it down to the bare bones of the 14th Amendment, interpreting born in the United States and subject to the jurisdiction thereof as a very limited exception. So this is what the Supreme Court said, that a child born in the United States to parents of foreign descent is a citizen of the United States unless the parents are one of four exceptions: foreign diplomats, who are just here to represent their country and not residing in the United States on a permanent basis; two, foreign public ships, so foreign ships that have come into the harbor and a child might be born on them; a child born to nationals of an enemy nation that are occupying U.S. territory. So if someone invades U.S. territory and their child is born there, the Supreme Court said those people would not have been interpreted to be U.S. citizens. And the last one is the one we just went over in the Elk case, the exception of Indian tribes not taxed. So that's pretty much the reigning jurisprudence on what we have, reigning law on how we interpret subject to the jurisdiction thereof. It has been very limitedly interpreted by the Supreme Court now to only those four exceptions. Otherwise, if you're born within the territorial limits of the United States, you become a U.S. citizen under the 14th Amendment. Now, it's important to realize that we are, just on context, a global context, we're one of the very few countries who gives this type of citizenship. Most countries in the world have a birthright citizenship, that you're born from a citizen of your country, you would inherit citizenship. We're one of the very few countries in the world that give citizenship based on the location of your birth, as well as through birthright citizenship. So I'm about to wrap up, but I'm going to explain really quickly a couple of ways that you can lose your citizenship. There are two real quick cases. One deals with an Italian American citizen who was born to an Italian father, an American mother in Italy. By virtue of an act passed by Congress, he had citizenship through his birthright, through his American mother. However, the statute at that point in time provided that you can lose that citizenship if you not satisfy a residency requirement. By the time you turn 28, you have to live 5 years within the United States. Aldo complained that this was unconstitutional, that just because he didn't live in the United States for a certain period of time before an arbitrary age, his citizenship should be taken away. However, the Supreme Court held what Congress gives, Congress can take away, because birthright citizenship was not a constitutional right at that point in time, and still not today. Congress can limit how that right is given. In Nishikawa v. Dulles, a dual citizen of Japan and the United States. He was born in California, but he went to go study to get his education back in Japan. Unfortunately for him, World War II broke out in the meantime. He was conscripted into the Japanese army, and if he had refused, he would have been thrown in prison for 3 years. So, when after World War II, when he tried to come back to the United States to get a passport, the U.S. Embassy in Japan said, no, you lost your citizenship because you took up arms against the United States. Now, what the Supreme Court held here is that voluntariness is the key inquiry here to determine whether you can have your citizenship taken away. Because again, he was a constitutional, his right to citizenship was constitutional. He was born in the United States. So it's a tougher burden to take away his citizenship rather than just an act by Congress granting citizenship. They can have conditions to that. So the voluntariness was a key inquiry. The Supreme Court ultimately held that the burden of proof to prove that the act of taking up arms against the United States was voluntary was on the government. The dissent argued that the only person with evidence here as to whether it was voluntary is the person trying to claim citizenship. But the Supreme Court said citizenship is such an inherent, important attribute of every American citizen that we have a very high burden of proof, and the government has to show by clear and convincing and unequivocal evidence that you voluntarily move to attack and overthrow the United States government. So those are the ways to lose your citizenship. It's a very high burden, but what was the outcome? His citizenship was upheld. He was a U.S. citizen because it was held that if he had not answered the conscription notice by the Japanese government, he'd been thrown into prison. So the government couldn't prove that he wanted to be conscripted, and so he was a U.S. citizen. He was going to come back. But that's it for my presentation. I'll turn it over to Brian. Thank you.
All right, thanks, Doodle. Good morning, everybody. As a former student of Dr. Peterson, it's always great to be back in this class. If you guys are excited to be here with me. Hopefully over the next 10 or 15 minutes, you can learn a little bit about the Equal Protection Clause. Just raise your hand if you've already heard of the Equal Protection Clause. Okay, not many people. What about, can anybody name a case that has involved the Equal Protection Clause? Anybody know a case? Well, there's been a lot of cases, and it applies to a lot of issues. So even if you don't necessarily know a case, you may be familiar with some of the issues that it applies to. One of the most famous and more recent cases was the Obergefell case, which is the same-sex marriage case, which just recently came out. That involved the Equal Protection Clause and some other stuff too. But the point is, this is a clause that is still very important, still being used in current cases and used on important issues. So hopefully over the next 10 minutes, we'll get to learn a little bit about it. First thing I want to do is just look at what it says. Then I want to talk about, just briefly about kind of what it means, and then we're going to look at how it's been applied by the courts. And that's kind of the technical part, but it's worth looking at. And just for nothing else, if you can be familiar with it a little bit when you hear about it, hopefully you'll know a little bit about what a court does when it considers challenges to laws under the Equal Protection Clause. So the first thing, looking at what does it say, it's at the end of Section 1 of the 14th Amendment. And Section 1 of the 14th Amendment contains a list of things that a state can't do. At the end of that list, it says the state can't deny to any person within its jurisdiction equal protection of the laws. Okay, so that's what it says. Pretty short clause, pretty straightforward. Second point is, what does it mean? It's pretty self-explanatory, but the point of it is that the Equal Protection Clause is that persons that are similarly situated should receive similar treatment. Okay, if a law puts people into different classifications, into different categories, if it discriminates against people, then that law could be challenged under the Equal Protection Clause. And then what a court would do is look at that classification, look at that category, and determine whether or not that's a valid classification or category. So at the end of the day, laws should really generally treat people equally unless there's a good reason why there should be some kind of category or classification. All right, so the next thing I want to talk about, this is how it works. This is how courts apply the Equal Protection Clause whenever it's brought, whenever a challenge is brought in a case. And the Supreme Court has come up with a framework to apply whenever there's a challenge. And there's 3 levels of scrutiny that can be applied. What do we mean by scrutiny? That's when we look at something, a critical observation or an examination of a law to see if it violates the Equal Protection Clause. There's 3 levels. There's a very high level, there's a medium level, and then there's a low level. So I want to talk about each one of those, when those are used, and I've got a case example of each one. So the highest one is something called strict scrutiny. How many people have heard of that term? Okay. Strict scrutiny is the highest level. What that asks is the law narrowly tailored, and is it the least restrictive means to achieve a compelling government interest? Okay, we may see this standard and not know exactly what that means, but we can tell that's a pretty high bar. It's got to be narrowly tailored. It has to be the least restrictive means and a compelling government interest. Not just any government interest, but a compelling government interest. Things that are going to fall under this category are what we call suspect classifications. Some examples include race, national origin, religion. There's another thing that comes under strict scrutiny is fundamental rights. If a law creates a classification that burdens a fundamental right, that's going to also be subject to a strict scrutiny standard. Things in that category include interstate migration, voting, access to courts. Fundamental rights is something we're going to hear more about coming up from Mr. Wynn, but I just want to make you aware if a law creates a classification that burdens a fundamental right, it's going to be subject to strict scrutiny. Case example I have under this is called Brown versus Board of Education. Has everybody heard of this case?
Yes.
All right, this is a very important case. I think everybody knows the facts. But in the 1950s and before, public schools were segregated based on, there were white schools and black schools. And the idea was that as long as those school facilities were equal, it was okay if they were separate. And that was something called separate but equal. That was challenged in this case. Under the Equal Protection Clause, the court applied strict scrutiny. This is a classification based on race. And Earl Warren, who was the Chief Justice of the Supreme Court, wrote that separate but equal facilities are inherently unequal. Segregating public school education based on race instills a sense of inferiority among African American children, and so we're going to strike down that law. It violates the Equal Protection Clause. Okay, next level is the middle level. This is intermediate scrutiny. This asks the question, is it substantially related to an important government interest? So this language is still fairly strong. It's not quite as high as, is it narrowly tailored? Is it the least restrictive means? And is it a compelling government interest? Most of the things that fall under the strict scrutiny standard of review, those are going to be struck down. It's really hard to meet that burden. This middle category, sometimes you can meet it, sometimes you can't. Things that fall under this category are going to be what we call quasi-suspect classifications. That's gender, legitimacy classifications. Got a case example called United States versus Virginia. In that case, there's a public school in Virginia called the Virginia Military Institute. And they had a long-standing policy of male-only admissions. Okay, has anybody heard of this case? All right. So that was challenged under the Equal Protection Clause. What's interesting is it wasn't just a woman who wanted to go to this school and then sued, but the United States is actually the plaintiff. The United States sued Virginia. And we all know they've got some pretty good lawyers working for them. So they raised the argument that this violates the Equal Protection Clause. The court is going to apply an intermediate scrutiny, and Justice Ginsburg, writing for the majority, says that this law denies to women, simply because they're women, full citizenship stature, equal opportunity to aspire, achieve, participate in, and contribute to society. So this law is going to be struck down. Women can go to the Virginia Military Institute. All right, last level I want to talk about, this is the lowest level of scrutiny. This is called rational basis. A rational basis asks, is it rationally related to a legitimate government interest? And you can tell this standard is really the lowest. It's just rationally related. Remember the other one, strict scrutiny, had narrowly tailored, least restrictive means? This is just rationally related to a legitimate government interest. Doesn't have to be a compelling government interest. Doesn't have to be an important government interest, just a legitimate government interest. So if this standard is applied, a lot of times, law might be upheld because the court might say, well, under this standard, it's really not that unreasonable. Some of these other classifications are age, wealth. And the case example I have on this one is Gregory versus Ashcroft. What happened in that case, the Missouri Constitution said that when state judges reach the age of 70, they have to retire. And that was challenged under the Equal Protection Clause. The Supreme Court said, well, Missouri has an interest in promoting competent state court judges. That's the legitimate government interest that we need. And the court noted that there's a connection between increasing age and declining physical and mental capabilities. So it said, in light of that, this rule is not unreasonable. So we're going to uphold this rule. And that's the one example out of the three where the law is actually upheld. That's the lowest level of scrutiny, rational basis. So the other two struck down, but this is one that ended up being upheld. All right, I think I have just another second. I've got a trivia question for you guys. The 14th Amendment said that no state shall deny to people within its jurisdiction equal protection of the laws. It doesn't say anything about the federal government. So does equal protection apply to the federal government? How many people say yes? Okay.
Yes.
I say yes only because the Constitution originally only applied to the federal government.
Right.
But the 14th Amendment was later used to apply the Bill of Rights to the states.
Exactly.
So first it applied to
You're exactly right. The equal protection has been applied to the federal government through the Fifth Amendment. And I don't know if you guys have learned about this, but the Fifth Amendment contains the Due Process Clause. And the Supreme Court has said that essentially due process prohibits the denial of equal protection under the laws. That applies to the federal government. So equal protection does also apply to the federal government. Just wanted to mention that as a trivia question. So Hope you guys enjoyed that. The next presentation is going to be on the Privileges and Immunities Clause. There's a question right here.
Right, previously we talked about the case being appealed about the judges in Missouri having to retire.
Yeah.
Don't we have a protection against age discrimination?
We do, and that was actually challenged under both equal protection and age discrimination. But the court determined that it wasn't age discrimination because it noted this connection between increasing age and declining mental capabilities. And also, the standard is very important because this is only the rational basis standard. And so as long as there's just some reasonable connection between what the law does and the government's legitimate government interest, it could be upheld. You know, if you were to apply a strict scrutiny standard, it wouldn't be upheld. But under the rational basis standard, it would be. And a lot of times, if you see Supreme Court cases, there's a big disagreement about what standard should apply. You see a lot of dissents, you know, justices arguing either the wrong standard was applied, or maybe the right standard was applied, but the analysis wasn't good. There's always a big battle over what standard is going to apply, because that has a big impact on what the outcome is. And then the analysis goes from there. So under a rational basis review, something like that would be upheld. All right, any other questions before I turn it over? All right, thanks, guys.
Good morning, folks. I'm going to talk about the Privileges and Immunities Clause and the Due Process Clause of the 14th Amendment. There's a lot of substance to the Due Process Clause. Unfortunately, I'm not going to have a lot of time to go into a lot of the substance of it, but I will give sort of the rapid-fire version of this. So the Privileges and Immunities Clause of the 14th Amendment says that no state shall make or enforce any law that abridges the privileges and immunities of citizens of the United States. So what are the privileges and immunities of the citizens of the United States? Do they include the Bill of Rights? Anybody got an idea on that? Yes?
Yes. Yes.
Wrong. In an early case, one of the first cases to interpret the 14th Amendment were the slaughterhouse cases. And in this case, what exactly was going on isn't so important, but the conclusions were. The 14th Amendment concerns privileges and immunities of citizens of the United States as opposed to citizens of the several states. And that conclusion is based off of the fact that the 14th Amendment itself differentiates between the two. Citizenship of the states, citizenship of the United States. The rights that are protected by the Civil Privileges and Immunities Clause includes stuff that's that you have rights to based on the federal government, the national character of the government, the Constitution and its laws. The privileges and immunities of the several states, those are rights that are sort of more basic to your just sort of everyday rights, like freedom, just your sort of basic civil rights, contract, property rights, stuff like that. And the Bill of Rights, all that was originally was a protection against the federal government from infringing on those rights that were otherwise granted to you by the states. And that's not what the Privileges and Immunities Clause was. Although there was some debate in the congressional debate that is actually what the intent of the Privileges and Immunities Clause, to apply the Bill of Rights to the states. The Supreme Court ruled that it wasn't, and the dissent said that it made the Privileges and Immunities Clause a vain and idle enactment. So stuff that is included in the protections of the Privileges and Immunities Clause, suggested by the court in the slaughterhouse cases, includes stuff like protection by the federal government when you're on the high seas. How and why the state governments might try to infringe that right, who knows. Protection by the federal government when inside another country. The rights to use navigable waters in the U.S. The right to become a citizen of the state by moving to it and residing in it. The right to hold and seek federal offices. These are privileges and immunities of citizens of the United States. And after a long time of no one caring about the Privileges and Immunities Clause, the Supreme Court said that the right to travel from one state to another is also a privilege and immunity of the citizens of the United States. But, as you know, the Bill of Rights do apply to the states. Why is that? Well, that's because of the Due Process Clause. The Due Process Clause says that no state shall abridge, no state shall deprive life, liberty, or property, any person of life, liberty, or property without due process of law. The Due Process Clause protects procedural rights, it protects fundamental rights, and it incorporates the Bill of Rights against the states. Procedural due process includes this concept that whenever a state attempts to burden a liberty or property interest, it has to give you basic procedural protections, including timely and adequate notice of the action that's going to be taken and the grounds for doing it. You have to have an opportunity to be heard where you present evidence and present an argument for your case, and you have to have an impartial decision maker deciding the matter for you. And depending on the importance of the liberty interest or the right that you have, you're going to have different levels of protections, procedural protections. So if you have like a statutory benefit that's given to you that otherwise doesn't exist, you might have less due process rights, as say whenever you're charged with a capital offense and you're facing the death penalty or something like that. Okay, so there's this other concept in the due process called substantive due process. This is the protection of fundamental rights. And fundamental rights are basically principles of liberty and justice that lie at the center of our civil and political institutions. These are super important rights. They're sort of, by their nature, part of due process. You cannot have due process without these rights. And this is how the courts have applied the Bill of Rights to the states, because these sorts of rights, these are fundamental rights that no state can deprive anyone of. However, not all the rights in the Bill of Rights have been incorporated. Just to give you some examples, rights that the Supreme Court has applied to the states is the Establishment Clause, prohibiting favoritism of religion. The Free Exercise Clause, which gives you the freedom of religion to practice however you want. The freedom of speech, press, assembly, right to petition for redress of grievances. The right to keep and bear arms was actually the last one that was incorporated in 2010. The right to be free from unreasonable searches and seizures. The double jeopardy clause, which means that you can't be tried for the same offense twice. The privilege against self-incrimination, you can't testify against yourself. The takings clause, which means that the state can't take property from you without it being for a public purpose and just compensation. You have a right to a speedy public jury trial, and you have the rights to have your accusations brought to you before the trial happens. The right to confront witnesses against you. You have the right to question witnesses that the state brings. You have the right to subpoena witnesses, which means you can compel testimony of witnesses in your favor. You have the right to effective assistance of counsel, not good assistance of counsel, and you have the right against excessive bail and protection against cruel and unusual punishments that were incorporated through the 8th Amendment. However, some rights have not been incorporated. These are not determined to be fundamental rights. The 5th Amendment's right to an indictment by a grand jury, which is basically a jury gets together, they look at evidence and determine whether or not there's a basis for a charge, correct? And you do not have a right to a jury trial in civil cases. In civil cases, just basically whenever you sue somebody, whenever one private person sues another. And you do not have the benefit of the reexamination clause of the 7th Amendment. And that is just basically a judge can't overrule a factual finding by a jury in a civil case. There has been no ruling from the Supreme Court one way or the other on whether or not the 3rd Amendment's prohibition against ordering troops has been incorporated, so we don't know whether Texas can post up the National Guard in your apartment or not. The vicinage clause, which basically just means that the jurors from, in a criminal case, they have to come from the state and the district in which the offense occurred, or alleged offense. And the right against excessive fines in the 8th Amendment hasn't been incorporated. However, the other rights, these are real close to the other 8th Amendment rights. I would imagine that that would be included as well. So what are some other liberties that aren't specific to the Bill of Rights that are included in the Due Process Clause? Well, at one time, the Supreme Court, in what was called the Lochner era, this is the early 20th century, it said that the right to contract was one of these rights that couldn't be infringed. And so in Lochner versus New York, for example, there was a law that said that bakers couldn't work more than 10 hours a day or 60 hours a week. This violated their employer and the baker's freedom of contract, so the court struck that down. The court struck down lots of other economic regulations, such as labor laws, minimum wage laws, child labor laws, stuff like that. But eventually that was overruled because there's an interest of the state. If it has a legitimate interest over certain things, this is not a liberty that's so protected that you can't regulate it. And most of these things are subject to rational basis review. So if the state has like just some purpose and the law could be argued to accomplish the end, then that is a valid law. Okay, the Due Process Clause, other rights that have been determined to be fundamental are rights involving privacy, procreation, family, stuff like that. So in way back in the 60s, the Supreme Court in Griswold versus Connecticut recognized the fundamental right to privacy. In that case, it said that a ban on contraception couldn't be applied to married couples because you have a basic right to determine whether or not you want to bear children. And in Eisenstadt v. Baird, which is actually an equal protection case because that was a fundamental right, the classification for married versus unmarried people was stricken down. And that right has obviously been extended in Roe versus Wade to a right to an abortion. This is a privacy right, the right to decide whether you want to have a child or not. Planned Parenthood versus Casey upheld Roe, but it sort of altered Roe versus Wade a little bit and says that prior to the viability of the fetus, which is whenever it can be born and whenever it can survive outside the womb, the state can regulate abortion, but it can't impose undue burdens on the right. Other fundamental rights involving like intimate relations is the right to marry. The right to marry is a fundamental right. And in Loving versus Virginia, this is also an equal protection / due process case. You have the right to marry whomever you want, because this is a personal choice. So if you want to marry somebody of another race, you have the right to do that, and the protection clause also played a role. In Zablocki v. Redhill, the court struck down a law that required people to get permission who were late on child support payments before they can get a marriage license, because that infringed on your right to get married. That was stricken down. In Turner v. Safley, there was a prison regulation. Yeah, there was a prison regulation that that said that the prisoners had to have permission from the warden to get married. That infringed on the right to marry, so that was stricken down. In Lawrence v. Texas, Texas had a law banning homosexual sex, basically, and that was stricken down because you have the basic fundamental right to privacy, to engage in whatever intimate relations that you choose without undue arbitrary interference from the government. And in Obergefell v. Hodges, as Brian mentioned, that involved sort of a dual situation from Lawrence v. Texas, the right to engage in whatever intimate relations that you wished, and the right to marry whomever you wanted. So because that violated due process, that was stricken down. These aren't the only fundamental rights that exist. They're more than just to kind of give you an idea. For example, the due process clause that in the Fifth Amendment, which applies to the federal government, also protects fundamental rights. And one of those fundamental rights, the court has determined, is equal protection of the law, which is why the Equal Protection Clause of the 14th Amendment applies as well to the federal government. And with that, here's the 14th Amendment.
All right, I think we're about out of time, but if there's any questions somebody wanted to ask.
You said you cover a right to speech trial. What do the courts and the law determine as a speech trial? Some trials go on.
A speedy trial is basically, the government can't like hold you indefinitely without trying you for an offense. They can't arrest you and just hold you in a cell for a really long time. You might know the answer to this better than I do.
Yeah, the idea is that if the government's gonna charge you with an offense, they have to try you for the offense. They can't just charge you and then leave it. So there is also a statute of limitations, which are laws passed by states and the federal government that say that you have to be charged within a certain amount of time from the date of the crime. But the idea, under the Constitution, what is a speedy trial is pretty broad. It could be several years, just given the reality of trial dockets and whatnot. So for there to be a unconstitutional deprivation of your right to speedy trial, it would be several years, and there would have to be some advantage the government's trying to obtain by delaying the trial as well.
All right, well, thank y'all very much. If y'all have any questions after, just come up and we'll hang out for a few minutes. But thank y'all for coming and being so attentive.
All